Greetings, my fellow Americans. Today I would like to talk to you on the subject of unpublished opinions. Now, an unpublished opinion is basically a ruling issued by a court that is not allowed to be precedential because it literally says it cannot be published. It's simply a memorandum. It doesn't hold any precedential value. In Montana, we don't have a middle range appellate court, and as far as I can tell, it's really the only state in the union that actually has that. Most states have your district or other equivalent court. Sometimes they're called superior, sometimes they're called other things, but basically you have your basic court of state court, and then you have a middle range appellate court. Then you have, if the appellate court rules against you, then you can go to the state Supreme Court. In Montana, we don't have that. We literally have the district courts, which are the state courts at the county level, and then we go directly to the Montana Supreme Court, which means all the power really in the state for any kind of appeal rests in one place with one group of 7 people. And of course, that is usually doctrined by whoever is the head judge of the court. And this presently is Mike McGrath, which, quite frankly, is another podcast entirely in and of itself. The man has no right to be in office, not that office. There's actually state law that prohibited him from running for office at the time he did run, and everyone ignored it. Just, once again, the wonderful system as it exists. But anyway, in Montana, we have what are called internal operating rules. And the Montana Internal Operating Rules, Section 1, Paragraph 3C, gives the Montana Supreme Court the ability and authority to issue what they call now memorandum opinions. Prior to 2015, they were actually called unpublished opinions. The theory behind this is that with all the cases that go before a court, if you have the same rulings and the same decisions over and over and over and over and over again, then you're going to have a redundant elements of precedent. So if you have someone say, I want to rule on whether or not my land can have, cows on it. Okay, we rule on that issue. Well, turn around a week later, the same matter comes before the court. I don't know if I can have cows on my property. Well, we already made the decision in this prior case, so rather than simply refer back to that case and say, okay, this case has been decided previously upon prior merit, here's the prior case, what the Montana Supreme Court is elected to do is to issue memorandum opinions, which basically they can rationalize and reason their reason for whatever association. The problem is in actual practice, whereas the theory is to prevent an overburdened redundancy of precedent, in practice it allows for significant abuse because it literally does not require the court to uphold the law. It requires no requirement to adhere to precedents. The court can literally rule completely opposite decisions back to back. For instance, if Jim Bob has the original decision on the cows and Franklin D comes and says, hey, I want the same ruling, they don't like Franklin D because maybe he's black, maybe he's, from California, maybe he's just, they don't like the fact his name is so close to the president. Whatever their reason for bigotry or bias, they can say, you know what, we're going to rule completely opposite for Franklin D. And Franklin D is going to end up with this, opposite decision, and we're going to declare Franklin D's decision an unpublished memorandum. It has no precedential value. You can't cite this authority. You can't in any manner, shape, or form use this decision, but we're going to hold it only against Franklin D, because Franklin D is the only person this ruling is against. Anyone see an argument of invidious discrimination here? And we'll talk about invidious discrimination in a little bit, because that's a big issue and how it ties into this. But the idea here is that the Montana Supreme Court has elected itself through its own internal operating rules to basically say it can do whatever it wants. It doesn't have to follow the law. All it has to do is say, we're going to make this an unpublished or memorandum opinion, and therefore we don't care whether what we say actually has any relationship to how we've ruled in the past. So, and of course, as I mentioned, the big problem here is that each of these individual decisions go against one person or group or whoever. It's not applied to the state as a general rule. There's no equal protection or equal application of law. It's a specifically targeted, unique, discriminatory practice aimed at one party or a group of parties if it's multiple groups that are appealing. Montana Constitution, Article 2, Section 4. It actually prohibits this. It actually says that it prohibits discrimination against, and I'm going to quote this, any person in the exercise of his civil rights on account of race, color, sex, culture, social origin or condition, or political or religious ideas. Most often, these are are political ideas. If you don't like a certain person or the political officer or whatever else, maybe you've spoken out against someone they like or someone they're running for office. Maybe you own a business that the city government wants for some purpose. Whatever. Usually, that's what it comes down to when it comes to these kind of decisions, or they just don't like you. They don't have, as a political position, as a political person in power of position, it becomes a political belief. If your beliefs and likes and dislikes differ from somebody who's office, it's a political idealism problem. Because the moment someone is in a political office, they represent a political idea. And if you oppose them and they use their office against you, it becomes political discrimination. But Montana has used this practice to in my case particularly, to single me out and say that every deprivation of civil right, everything they've done to me, the threats they've imposed against people in my life, the undue influence, all of the issues, everything that they've done, all the tampering, everything, it's allowable. Because, and every time they issue a ruling against me, they always issue a ruling as a memorandum or unpublished opinion. They don't want the rulings against me to ever be something that stand out as precedent, because they don't want the rules to apply to the rest of the state. They only want them to apply to me, and they want to use this method to pigeonhole me into an area of law where I'm not protected by civil rights. I have no civil rights, I have no civil liberties. And other people have this problem too. It's not just me. Other people are all the time complaining about this unpublished opinion process. And nobody wants to do anything about it, because Montana Supreme Court is, guess what, is the one who's going to make the ruling, and Montana Supreme Court doesn't want to change it. So again, we do not have a middle grade appellate court that we could actually take this to. If we sue in state court, the state court's going to say, we're not going to go against the Montana Supreme Court. And then, of course, the Montana Supreme Court's not going to change their own rules. So we're stuck with this system unless we have some kind of an outside oversight. Mike McGrath, as I mentioned earlier, actually has two particular conflicts when it comes to me, and he uses this system to actually ignore that. He was actually the prosecutorial attorney general who defended the appeal on me when he was the attorney general. So he actually has a conflict of interest and should not be allowed to be involved with this. But because he issues memorandum opinions, they're non-citable, so the conflict of interest is irrelevant. And then, of course, they use this system to defend the corrupt judicial system. If you have a corrupt judge, if you have a judge who's just doing whatever he wants, whenever he wants, whatever whim he wants, they use this practice to where they can just say, okay, we're going to issue a memorandum opinion that upholds the actions of this judge, but it's not going to be presidential. We're not going to say that all judges have this ability. We're just going to say this judge has this protection, because we're going to just use a memorandum opinion. It doesn't get published, doesn't end up in the national circulation, and it stays in Montana. Once again, the great Montana conspiracy at work. I'm actually going to talk about a couple of cases here, because it's really important to understand this is not an issue unique to Montana. This is not an issue that started here. It's an issue that Montana probably saw in practice somewhere else and said, hey, this looks pretty good, let's do it. Or they took the idea and then twisted it in their own variation, whichever happened. But there's a case, a United States federal case out of the 8th Circuit. It's called Anistoff versus United States. It's 223 Federal 3rd 898 is the actual code. Although it was actually vacated as moot by the 8th Circuit Court in 235 Federal 3rd 1054. Both of these are in the year 2000. The reason why it was rendered moot, by the way, was because the case was settled before this was a pre-judgment determination and discussion. So the case was settled before it actually reached a final judgment, and therefore the 8th Circuit has considered it to be a case of moot, because the issue was not finalized. Therefore, the preliminary decisions are moot. However, the discussion is fantastic, and you should read the case. In particular, it says, it talks about this issue, and the best summary of the whole case that I love is, and I'm going to quote it, it says, these courts basically have, quote, we may have decided the question the opposite way yesterday, and this does not bind us today, and what's more, you cannot tell us what we did yesterday. Let's use the cow decision. We've decided the question the opposite way yesterday. We let Jim Bob have his cows on his property yesterday. This idea does not bind us today. We don't have to hold to Franklin D. to have this idea that the same rule applies to him. We don't have to be bound by it. And then you can't even tell us what we did yesterday if yesterday's decision is a memorandum decision. You can't even tell us that we ruled this way here. Let's flip the script. Let's say that Franklin D was the first one ruled on, and or let's just say that both decisions are memorandum decisions because they don't want either one to be precedent. They want him to have the flexibility to go back and forth. Franklin D can't quote Jim Bob's story or his case because it's non-presidential, it's non-citable, it's a memorandum opinion. So he can't say, hey, wait a minute, you just said that Jim Bob could do exactly what I'm asking for. Doesn't matter. It's a memorandum opinion. You can't tell us what we did. If I say that it's okay for this officer to shoot you in the chest, it's okay. It's a memorandum opinion. If I say it's okay for someone to steal your property, just to take it, seize it, sell it at public auction, it's okay. It's a memorandum opinion. You can't tell us we did anything wrong because it's a memorandum opinion. And you can't come back later and cite that case for somebody else when we don't want to. You see an unequal balance here? When one group of people or one person or whatever are treated differently under the law, it's an institutional discrimination. It's an idea that the institution of government is applying the laws differently to different people, even if they follow the law. The fact, if the law is written in a way that favors one person over another, or even if it's not the intention of the way it's written, but it's the way it's implemented in practice, it's bad. There's another case called Yick Wo. It's Y-I-C-K space W-O versus Hopkins. It's actually decided back in 1886. That's how old this precedent is. It's literally back in the 1800s. It's 118 U.S. 356, if you want to look it up. But it describes institutional discrimination. And it says, and this is, I'm going to quote this, the law itself be fair on its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and an unequal hand, so as to practically to make unjust and illegal discriminations between persons in similar circumstances material to their rights, the denial of equal justice is still within the prohibition of the Constitution. Specifically, 14th Amendment. But that is another later issue, and that's the invidious discrimination. It comes out as it is later applied. But in this particular case, in 1886, the U.S. Supreme Court said you can't make a law that allows for a group of people, any case, if it's applied unequally with an evil eye, malice or whatever else, an unequal hand, not equally applied to people, that it violates the Constitution, the United States Constitution. And that's what this internal rule does. It allows for the memorandum opinions, which in practice allow for an unequal application of law to whomever they want. If you donate to Mike McGrath's political campaign, you're going to win all your cases. And we just issue them as memorandum opinions. We don't have to worry about anything because, hey, we don't have to. Whenever a government is held to a standard, by the way, that says we don't have to, there's a problem. Because we're talking about a government that's supposed to be equal and fair. And you have a government that says we don't have to. There is no equality. There is no fairness. It's an impossible standard. You can't sit here and have this happen to you and say, oh yeah, that was right, that was fair. That was equal protection under the law. But what this does is it violates the basic axioms of the judicial system. What it does is it says the judicial powers and the fair administration of justice are thrown out the window. We don't care about them because we don't have to care about them. They're memorandum opinions. So when you have the basic concept of how a court is supposed to work, say we don't have to follow those rules because it's a memorandum opinion, you're no longer being bound by even constitutional law. And remember, all law is bound and created and founded upon the Constitution, whether it be the state constitution or the federal constitution. No other law can exist without that foundation. So if you're going to ignore the foundation of which your law is based upon, where is your credibility? Where is your integrity? Where is any of it? It doesn't exist. But when in Yick Wo, the court determined it was a practice that might appear fair and impartial. If it's applied with an evil eye and an unequal hand, it's prohibited by the 14th Amendment of the United States Constitution. And that's invidious discrimination. Where and I'm going to quote another case, where the impetus for the discrimination is private, the state must have significantly involved itself with invidious discrimination under the 14th Amendment. And that's a case called Moose Lodge versus Irvis, 407 U.S. 163. And what it does is it says that if the state is involved in an unfair application of law, if it's significantly involved in a way that discriminates against a private person or private group or private whatever, it's significantly, the word coming directly from the court, significantly involved in invidious discrimination. So when you have an entire court system set up to where it can just ignore all law and just write out an opinion and just say, and just right at the top, this case cannot, this is a memorandum opinion, cannot be cited and is not considered a precedent, then they can do whatever they want. And that is most definitely significant involvement in an unequal application of law and invidious discrimination. Basically, what I'm trying to say is the practice of unpublished opinions is a foundational cornerstone of the Great Montana Conspiracy. It's what allows this misconduct to stay in place. Because if it comes up as an issue that needs to be challenged and they don't want anyone in the national arena to look at it, they issue it as memorandum opinion, it doesn't get published. And when I say published, by the way, every year we have what are called the federal reporters, and they collect the state decisions, and we have, that's what the federal third, by the way, the Federal Registry. But you have different collections. You have the Pacific Reporter, you have the Federal Reporter. The Pacific Reporter is what records our cases. And they issue volume after volume after volume of collected, published opinions that can be cited and quoted around the country. Of course, unpublished and memorandum opinions don't get published. Therefore, nobody else knows about them, and they don't run in conflict. I mean, can you imagine if you had 20 different rulings on a subject, and you just basically picked which one of those you wanted to be your precedent? Hey, I want to use this one today, I want to use this one tomorrow. Oh yeah, I used that one yesterday, but ignore that, I'm going to argue this case today. Well, of course not. That's what the whole purpose of a precedent is. A precedent means the court has set this standard in the past, and all other courts hereafter are bound by it. That's what a precedent is. But you can ignore it if you have memorandum or unpublished opinions. And what it does is this protects and shelters corrupt officials and institutions and gives corrupt high courts powers to literally ignore all law. It allows for political prisoners because they can disregard the constitutional civil rights. They can ignore whatever applications. They can ignore the fact that they're held 16 months without a trial, without any reasonable chance at bail. They can ignore the fact that the attorney goes in and argues on behalf of the state instead of their defendant. They can ignore all applications of fair law. They can take your property away. They can take, this is an exaggeration, of course, they can take your grandmother and put her in slavery if they want to, and just issue a memorandum ruling that upholds it. Hey, grandma's on a farm cutting wheat, and that's okay because the Montana Supreme Court says it's okay, but don't cite that opinion against anybody else because it's just a memorandum opinion. Do you see the issue? Well, I've probably rambled on about this enough, but if you have any questions about this or want me to expound upon any area that I've discussed, please by all means contact me. Information should be attached to this video. If not, by all means, please visit my YouTube channel or the original source of this podcast, which is monspiracy.podbean.com, where my contact information and Bill's contact information is. Bill is my associate who helps me with these. Please do also consider that this is a shoestring operation. Of course, to get better production, to get better videos, to get better quality, and be able to expand our resources, I hate asking for money, but unfortunately money is what this program needs to be able to operate in a better capacity. As I've mentioned in the past, I'm literally recording on an iPhone. I don't have a studio, I don't have a microphone, I don't have, any kind of a capacity even to do a split screen interview with somebody. Which I really want to do. I want to bring people on here and interview on this podcast so I can actually talk to people and say, what is your experience? If I do this and before I have some kind of a better setup or ability to edit these videos, it's literally going to be a phone conversation that I have while I'm on this video. You'll be seeing me and you'll be hearing someone else's voice, but you won't be seeing them because I just don't have a way to really do that. I mean, sure, I can try to do it through a split screen on if we both have iPhones, but beyond that, it becomes a little more difficult. I found that a lot of apps that allow for, like Hangouts as an example, the quality of the video is grainy, and of course it's hit and miss on a lot of this. So you get a lot of skips, a lot of distortion, you lose connections. It's not a very good quality production, which is why we need to have a better operating procedure to go from. So if you like what I'm saying, and if you want me to hear more of this, and you want me to be able to say it on a grander scale, by all means, help us support, whether it be resource donations, monetary donations, and of course, always, 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 we want to hear from you. We want to hear from the people who've been victims of this system, who've been victims of corrupt organizations, and we most definitely want to hear from anyone out there who has an issue specific to Montana. But even if it's beyond Montana, we want to hear from you. Thank you for your time, and always, please, if at all possible, stay free. Thank you. Bye-bye.